Hey guys, welcome to the Liberal Hive Mind, a channel solely focused on exposing the abundant hypocrisy of the left. The legal double standards in the justice system are being completely and utterly exposed. I just recorded a video on the issue of presidential immunity as oral arguments in front of the Supreme Court of the United States are released, but that's not the only issue in front of SCOTUS that we gotta talk about. We also have to address the clear double standard, and let's call it prosecutorial treatment, relating to individuals who participated in the events of January 6th, and of course everybody else. The reality is, we've covered it for years, J6ers are receiving some seriously harsh sentences from Joe Biden's DOJ, which in many cases seem excessive, unfair, and most importantly, selective. There's a standard for Donald Trump, a standard for Trump supporters, and of course, a standard for everybody else, namely Democrat voters, and that standard seems to be, well, no standard at all. But thankfully, once again, Supreme Court Justice Neil Gorsuch is asking all of the right questions and exposing Joe Biden's corrupt DOJ for their obvious prosecutorial bias. Let me show you guys exactly what I mean by that. We got some stuff to get into, so let's roll the tape. Alright folks, so the issue that's being discussed is the use and the application of U.S. Code 1512C. Whoever uses physical force or threat of physical force against any person or attempt to do so with the intent to influence, delay, or prevent the testimony of a person or official proceeding. We've been talking about this law for a while. Essentially, what it boils down to is the use of force, and in this case, protest force, to block, hinder, or delay an official proceeding. This is the felony count that many J6ers are facing, and actually Donald Trump is facing the exact same charge. And for those of you guys who don't know, this law or this statute was implemented in response to Enron destroying records. And so you have this corporate fraud statute that's now being used to politically prosecute J6ers. And the question on everybody's mind is, not only why is this law being used in this manner, but why is this law being used to explicitly target J6ers and Donald Trump, but nobody else? Well, here's Supreme Court Justice Neil Gorsuch challenging a Biden DOJ lackey on that exact issue.
I'm saying, okay, C1 does some things, and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view?
Yes, but there was a good reason for Congress to do it this way.
No,
it traces to the statutory history.
I understand
and
that.
I would just say that,
if I might, so what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
there are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal outburst, we don't think it falls within the actus reus to begin with.
My outbursts require the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. Are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we'd have to show that, yes, they were aiming at the proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent.
So mostly peaceful protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yes, if they intend to obstruct and were able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes.
If corrupt intent can be proved, quote, we would have to prove that they acted corruptly. So what's the interpretation here? What are we supposed to gather? That all of these J6ers, I believe that's 350 plus individuals that are being charged with this statute, that it's obvious that they acted corruptly in their attempts to disrupt an official proceeding, but when leftists do it, well, you know, we can't really go there. We can't really prove it. When one group of people blocks a proceeding, or when a Democrat politician like Jamal Bowman decides he's going to pull the fire alarm to delay an official proceeding, when that happens, well, it's hard to say what he actually meant to do by pulling the fire alarm. It's hard to say what these activists meant to do, even though they're literally chanting it on the street and occupying federal buildings, courthouses, you name it. When they do it, oh, we don't know. Hard to ascribe intent, but when the J6ers did it, the intent is clear and these people will face brutal retribution from the federal government, in many cases facing multiple year sentences for a mostly peaceful protest because of, quote, corrupt intent. This whole thing makes absolutely no sense to me. In fact, how do you even prove this supposed corrupt intent? What if all the J6ers that are being charged by the federal government on this exact statute, in their view, had moral intent? What if they thought they were doing the right thing and they were trying to stop something that they truly believed was corrupt? How do you prove something like that? That's the same question that keeps coming to mind. I just played this video in relation to Donald Trump's action, relating not only to January 6th, but the whole elector scheme.
For sure.
Justice Gorsuch, can I try one more time?
Well, let me just spin this out just a second, okay. Right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald, that's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives.
How are we to prove what people actually think or what their actual intent was? Well, what it really boils down to, at least to me, once again, is that there's just a blanket assumption that anything adjacent to Donald Trump, anybody who acts in protest on behalf of the former president, is corruptly engaged in insurrection. That to me seems to be the assumption. And that really is the core premise of these January 6 charges and also the charges relating to the fake elector scheme. That Donald Trump was acting corruptly for clear personal gain, putting personal interest above country, not because there's evidence of that, but simply based on the legal assumption that the DOJ is making. It makes no sense, because it only ever goes one way. Supposedly the only people who are acting corruptly, the only people who are being charged in these cases with this ridiculous post-Enron corporate law are J6ers and Donald Trump. Leftists burnt down the freaking country for an entire summer, but I guess their intentions were pure. Leftists actively engage in aggressive protests, attempting to disrupt official proceedings, but I guess their intentions are always pure, right? That seems to be the assumption, or at least that seems to explain the clear prosecutorial bias. Harsh, multi-year sentences targeting people who simply walked around the Capitol, branding them as felons and putting them behind bars for years. But of course, there's no such example of a leftist engaging in the exact same type of behavior, facing that kind of a harsh penalty. Not to mention, they're also using this law in their federal case against the former president of the United States. It's clearly bias, it's clearly election interference, it's clearly Biden's DOJ trying to send a message, and frankly, it should shock the conscience of every American. This right here, and this clear double standard of justice, is why Donald Trump needs to pardon so many of these people. Anyways, that's pretty much what I got for you guys on this one. Hopefully you enjoyed the video. If you did, make sure to leave a like and possibly subscribe. Thanks for watching, and I'll see you on the next one.